Hello guys, and welcome to another episode of my lecture. In my last lecture, I made it clear to you that the two cases that were interrogated, that's the RE Canadian land reclaiming and also RE low-line electric motors, both cases did not talk about the interposition of a corporate director between an alleged de facto director and the subject company. But something similar to that happened in RE Hydrodam Corby Limited, which is going to be what we'll be discussing about in this class. The fact was that a company which had only two directors, which were Channel Island companies, went into compulsory liquidation, and its liquidators bring claims for wrongful trading under section 214 IA against 14 defendants, who included two of the directors of Eagle Trust PLC, of which Hydrodam was by several removes an indirect subsidiary. It was alleged that they were responsible for the wrongful trading in Hydrodam from the date when they were appointed to be directors of Eagle Trust. You see, this fact is a little bit similar to that of RE HOLLAND, but let me explain to you. We have a subject company. That subject company in this case is Hydrodam. However, a director on Hydrodam is Eagle Trust PLC. That's a corporate director, right? Because it's a company. Now, when the subject company went into liquidation, the liquidators brought claim not against Eagle Trust PLC, but against two directors in Eagle Trust PLC, saying that those directors were the ones that were involved in wrongful trading of the company, and those directors should be liable because they were not acting as the directors of Eagle Trust at those material time when they did the wrongful trading. At those times when they did the wrongful trading, they became de facto directors acting for the company as directors, that is acting for Hydrodam as directors. That means those two people came out of Eagle Trust and they were independent de facto directors who were now on the board of Hydrodam and who made decisions for Hydrodam and no longer under Eagle Trust PLC, which is the judge director of Hydrodam. Now, the case was argued on the basis that sufficient fact has been pleaded to justify the inference that Eagle Trust acted as a shadow director of the company, and that as directors of the shadow directors, his directors were completely responsible for Eagle Trust conduct in relation to the company as its de facto or shadow directors. They argued again that Eagle Trust was a shadow director on Hydrodam's board, and not just that, that those directors who were directors of the shadow directors automatically became shadow directors or de facto directors. It will appear to me that the counsel in this case was just confusing shadow directors and de facto directors. In fact, while reading the case, you will see that he used it interchangeably at some point, shadow and de facto. It would appear that this counsel did not understand the difference between shadow and de facto directors. Now, Millet J, which I implore you never to forget that name because it's very, very important when distinguishing between shadow and de facto directors. Millet J held that the liquidators had failed to plead or adduce any evidence to support the allegation that the directors of Eagle Trust were at any material time directors of Hydrodam and the proceedings were struck out. As you can see, the bullet, it means that the court of RE HOLLAND here is saying something. So the court in RE HOLLAND said there are significant differences between this case and, RE Hydrodam. It is not alleged that Mr. Holland was a shadow director, and section 212 IA 1968, unlike section 214, does not extend to shadow directors. But this is what is very, very important. But it is of interest because of what Millet J said in the course of his judgment about what is needed to establish that the person is a de facto director. Now, when you look at what Millet J stated, Millet J gave us the difference between de facto and shadow directors. Now let us look at what Millet J stated. He said, I would interpose at this point by observing that in my judgment, an allegation that a defendant acted as de facto or shadow without distinguishing between the two is embarrassing. It suggests, and counsel submission to me support the inference, that the liquidators take the view that a de facto director or shadow director are very similar, that their roles overlap, and it may not be possible to determine in any given case whether a person was a de facto or a shadow director. He said, I do not accept that at all. He then went further. The terms do not overlap. The terms are not alternatives, and in most and perhaps all cases they are mutually exclusive, which is a very fundamental thing that you need to know about the differences. I told you that in this case, it was more of a distinction between de facto and shadow. But what makes it very important and what made the court cite this Hydrodam's case, especially the judgment of Millet J, is the fact that Millet J espoused, he gave us an insight on who a de facto director is, which is what is important in RE HOLLAND. So a de facto director is a person who assumes to act as a director. You would say that when we are reading the provision of karma, nowhere did they say assume. Do you understand? They only said hold him out or hold himself out, or the company describes him. But when you are talking about a de facto director, we must have assumed, especially when he was not appointed. You know, if there was a defect in his appointment, that is a specie of de facto director. The another specie is where he started working for the company as a director without being appointed at all. According to Millet J, he must have assumed such position. Do you understand? He is held out as a director by the company and claims and purports to be a director, although never actually or validly appointed as such. Now, to establish that a person was a de facto director of a company, it is necessary to plead and prove that he undertook functions in relation to the company which could properly be discharged only by a director. That is what is very, very important. That is what is very, very key. It must be proven that not only did he undertake functions, such functions which were undertaken by him must be such that only the directors can carry out. Do you understand? If that function is such that anybody below board level could have carried out, it doesn't make him a director. Millet J continued and stated, it is not sufficient to show that he was concerned in the management of the company's affair or undertook tasks in relation to its business which can properly be performed by a manager below board level. A de facto director, I repeat, is one who claims to act and purports to act as director, although not validly appointed as such. Can you see? They have given us certain rules. First of all, distinguish between de facto and shadow director. They do not overlap. They are alternatives, and in perhaps all cases they are mutually exclusive. Secondly, to establish a de facto director, you must prove that he took functions. But not just that, those functions must be such that only directors can take. Now we then go to who a shadow director is. According to Millet J, he said that the shadow director, by contrast, does not claim or purport to act as a director. On the contrary, he claims not to be a director. He lurks in the shadows, sheltering behind others who he claims are the only directors of the company, to the exclusion of himself. He is not held out as a director of the company. So you see, when you are talking about shadow directors are such that they do not come outside. They don't put their face out. No, they lock. You know the game hide and seek, where you go and hide and then you don't want the other party to see you. That is basically what shadow directors do. They hide behind the curtains. They hide behind those people who are real directors. Now, if you are going to prove shadow, you first of all have to prove that there is a de facto or there is a de jure director. The argument in RE HOLLAND was that Eagle Trust was a shadow director. If that argument is to be tenable or anything to go by, it would mean that they first have to prove that there is a de jure director or a de facto director. But Eagle Trust in itself cannot be shadow without anybody on the board. Shadow directors are those ones that lock, those ones that you don't see. That's what the court is stating in this case. But lastly, and most importantly, from what Millet J has said, Millet J stated that attendance at board meetings and voting with others may in limited circumstances expose a director to personal liability to the company of which he is a director or its creditors. But it does not, without more, constitute him a director of any company of which his company is a director. What Millet J is saying is that where you have a corporate director and there is a director acting on behalf of that corporate director, the fact that he attended board meeting, the fact that he voted in the name of the corporate director does not, without more, what we need to hold there is without more, does not, without more, constitute him as a director of any company of which his company is a director. So the court in RE HOLLAND then said the words without more are important. They indicate that the mere fact of acting as a director of a corporate director will not be enough for that person to become a de facto director of the subject company. Do you understand? The mere fact that Mr. Holland was acting as a director in paycheck in the board of the composite company, the fact that he attended meetings, the fact that he voted, does not automatically make Holland a de facto director. There has to be more. The question is, what will constitute more to make Mr. Holland a de facto director of those composite company? What will constitute more to make those two directors in Eagle Trust PLC de facto directors on Hydrodam? Do you understand? But then, that is where we are going to be ending our lecture for today. In our next class, we are going to talk about the case of Secretary of State for Trading versus T-Joel, as well as the case of Secretary of State for Trading versus Hall. And then we'll continue to look at other rules that the court stated in this case. See you in my next class.